Well, hello and welcome to the Living Your Best Life webinar series presented by the Huntsman World Senior Games. It's a monthly series where we cover a wide variety of topics that are really designed to help you live your best life. My name is Kyle Case, and I have the distinct pleasure of serving as the Chief Executive Officer of the Huntsman World Senior Games. And we want to give a shout out to everyone who has joined us so far. If you would take just a second in the chat box, click on that chat button down at the bottom of your screen and type in your hometown, your state, the country that you're from. We want to know where you are checking in from for this live webinar. So go ahead and hit that chat box. So far, we have a number of attendees that have joined us. And we've got someone that's checked in from St. George, Utah. Lori has checked in. And we've also got Boston, Massachusetts represented. So welcome to California as well. We know that our participants are engaged and coming in from all around the country and possibly even around the world. So welcome to each of you that have joined us today. We're going to jump to our expert presenter in just a moment. But before we do that, I want to cover one quick item, and that is this. We want this webinar to be interactive. We want you to get out of it what you want to. So if you have questions throughout this presentation as we go along, please take a moment and click on the Q&A button. Again, that is at the bottom of your Zoom screen. Click on the Q&A button, and you can go ahead and type in your question there. Now, we'll do our best to get through as many questions as we can, and we'll most likely hit those questions at the end of the webinar. But as we're going along, if you have a question, don't hesitate to type it in that Q&A box as it occurs to you, and then we'll do our best to answer as many as we can at the end. Now, on to our expert. Everyone knows that we need to prepare for the inevitable, but most of us procrastinate, thinking that it won't happen to us, at least not today. And you're probably right. But we tell ourselves the same thing day after day, and eventually it does catch up to us. That's why we call it the inevitable. The problem also is that maybe we don't know where to start. What do we do? Well, Paul Robbins has the answers for that, as well as any other questions, and we're excited to visit with him today. Paul Robbins truly enjoys helping others find the comfort and satisfaction of knowing their wealth is protected, as well as minimizing the expense of doing so. His 30-plus years as an attorney practicing both in California and Utah is enhanced by his experience as a business owner, an entertainer, a media news broadcaster, a volunteer in church and his community, an educator, a parent, and a grandparent, as well as an athlete and military service to throw in and round it out. In these combined experiences, he has gained insight into human emotions, attitudes, as well as needs. He is experienced in a variety of legal practices, but has found that estate planning is his favorite. It's a win-win way of using all those years of study and training. Welcome, Paul.
Thank you, Kyle. You know, with that introduction, it sounds a whole lot like a guy who can't keep a job.
Well, I don't think that is the case by any means, but we're glad that you're so experienced and that you have the ability to share that. And we're excited to learn as much as we can from you. You've been associated with the World Senior Games for quite a while. You mentioned athlete, and we know that you have competed for how many years at the Games?
Just a few over 20, I think.
Wow, 20 years of competing. What's your favorite sport? What's the sport that you compete in?
Well, I've done a lot of tennis, softball, and basketball.
Wonderful, wonderful. Well, we want to get right into your expert presentation. So, Paul, without any further ado, we'll turn the rest of the time over to you, and I'll come back at the end and we'll see if we can answer a few questions as we go along, okay?
Thank you very much, Kyle. Good to be here.
Paul.
And by way as being an expert, an unknown quantity under pressure, I think I fit that definition definitely. But in any event, what we'd like to do and what I hope to accomplish in these few minutes that we have together, and by the way, welcome. I'm glad you're out there, and I hope we can accomplish something today. What I'd like to do is acquaint you with the basics of estate planning. And to start that, let's have a couple of definitions. Estate planning is basically managing and disposing of all your estate. And most people think in terms of an estate as being some number of acres and a huge home and livestock and all of that. But basically an estate, and again another definition, is anything that you've acquired over your lifetime. And what we want to do today is to tell you what you can do with that and how you should do it, and you can stop worrying about it. I know a lot of people day by day think, gee, I ought to do something, but as Kyle suggested, you don't. But perhaps after we get through today, you'll know what to do and how to do it. Anyway, thanks for joining us. So, there's an old adage that if you fail to plan, you plan to fail. And that happens all too often. So let's just talk about your estate planning. What comprises an estate? You've got your home, any real estate, bank accounts, anything that's recorded or registered, valuables, art, jewelry, vehicles, any virtual property you may have, such as licenses or intellectual property, and perhaps even most important of all, as you see in that visual aid, children. Something that particularly you young couples need to think very seriously about. And just a quick story in that regard before we get started. I had a client, a couple, who were planning to do a trust. They were in the process of doing it, decided to go on a vacation before they finished it. And before they got home, they were both killed in an auto accident along with one of their children. The three remaining children became wards of the court. No planning had been done. And that's the last thing anyone wants, is for the court to determine who your children go to and where they go. As it turned out, these three children were split up among three different homes because of all the arguing between grandparents and uncles and aunts. In any event, just a side note, do some planning. So in planning, let's give you the options. There are a number of things that you can do in planning your estate, and some not so good. Others perhaps is something you should think very seriously about. So looking at this, the three most frequent, in fact, let's add one more to that after we get through with the joint tenancy, with that right to survivorship, which I imagine each of you who own a home and are married have that. Giving all your property away, that's always an option before you die. The only problem there is when do you give it away, because when are you going to die? That's a very tricky thing to do. And we talk about a living trust a little later on, but more importantly, what most people think in terms of estate planning is a will. And let's first discuss what's wrong with joint tenancy. And that's something that a lot of people think that if they've got their home in the wife's name or spouse's name, and one of them happened to pass away, then it's taken care of. But we're going to talk about something that this falls right into that category, as well as just about everything else, except what we're going to finish up with, and that is probate. The one thing I would like to do today is to spend some time talking about probate and what that entails. But as you read this, there are some good reasons that you do not want to deal with joint tenancy, because obviously it goes into probate to begin with. You don't want to put your children on that deed with you. Another quick story, I had a client, a little old lady that lived in St. George, Utah, and she had a daughter that lived with her only child, and they had an argument. She had put the daughter on the deed with her as a joint tenant, and when they had that argument, the daughter then convinced her that she needed to have that house in her name only. And as a result of that, she sold the house. And this little wonderful lady was out on the street, lived 3 years in a rest home, and did not have a great life after that. So you want to be careful about putting children on a joint tenancy with you. And there are also some tax problems. In any event, Um, let's talk about wills. A will is something that most everyone suggests and thinks is the way to go. And that does not avoid probate. Uh, Probate is something that is a legal process that the courts will determine where your property goes and how it goes. If you do nothing about it, you don't have a will, you die intestate, then there are laws of intestacy that every state has that the court will apply to your property. And it's a long legal process. Probate is something you want to avoid if at all possible. And by doing a will, you do not avoid it. You absolutely put yourself in that situation where you have to go through probate. And anyone who owns property in their names, whether or not they have a will, or if they do have a will go through probate. So let's just talk a little bit about what that process is. Wills can be written by yourself, holographic. You can have an attorney prepare a will for you. A will is a will. And as long as it's done properly, the courts will apply it. If it's not, then again, you go into what they call an intestacy. But the process of working with wills and the probate process, here is a list of things that you need to consider. The accounts are impounded, and all safety deposits likewise, all your mail, your accounts, bank accounts, savings accounts, checking accounts, they're all impounded by the court. There's a waiting process for all that to be done. Attorneys will be required to help you out doing that. And of course, there are fees with the attorneys. There are executor fees, those who take care of the property and get it appraised, get it prepared to pay the debts. This all takes somewhere between 9 months and 2 years. And the expense is generally somewhere between 5 and 20% of your entire estate, everything you own. So it's somewhat expensive, it's lengthy, but perhaps even worse, it's public. You go through a probate process, it's immediately published in the paper. People know about it, and what it does basically is just invites contests. It invites people to come in and say, hey, they owe me something, I want it, which just delays the process even further. And it's typically, I would say, about half of all probates, you're going to get some bogus claimant or someone who may have a claim, but it has to be proven, and that is a long and lengthy process. So probate is something that if you can avoid. Again, I don't know how you would do that except for the fact you give all your property away before you die. Just another story, the last probate that I conducted was an individual, a man who died, had 3 children, and a wife who claimed to be a common law wife. There was no actual marriage. And there was about a $250,000 estate. And 2 of the children were represented by me. The other one, the oldest child, felt like everything should go to him, so he hired his own attorney. And then the wife, or alleged wife, hired her attorney. So we had 3 attorneys involved on a $250,000 estate. It took 9 months to wrap it up. And by the time it was through, there was $100,000 left in the estate, which was divided among the 3 children. $150,000, that's over 50% of the entire estate, was literally wasted with attorneys. And I mean that as an attorney, it just didn't need to happen. So again, probate is something to avoid if at all possible. So let me just show you a chart here, or a table of individuals who have gone through probate and what actually happened to them. We've got Dixie Lee Crosby, and you see Walt Disney, Marilyn Monroe, just a few individuals that everyone knows, of course, and basically what happened to them and the cost of probate. Now, with Dixie Lee Crosby, you see that Oh, what was the cost of probate? About $781,000 on a little over $1 million estate. About 58% of that was probate cost. Here we have Walt Disney. About 29% of his estate went up in probate. Marilyn Monroe, 54%. And I can tell you again from experience, something that I had a little bit to do with in Las Vegas was the probate of a very wealthy man who owned a great deal of property, Howard Hughes. By the time they got through with his probate, $320 million had been spent. So obviously we're talking about a lot of money and people who have that much money, which poses the question, do I really need anything? Do I need to protect my property, or is it worth protecting? Do I really have an estate? And the answer to that is, if you have any of those items that I mentioned before, you do have an estate and it's worth protecting. You don't have to be rich to do some planning. And as Kyle mentioned earlier, you're thinking about it all the time. If you're like most people, and why worry about it? Why not get it done, taken care of? Make your choice as to what you want to do, so you won't have to worry about it anymore. But again, if you do a will or you don't do anything at all, that worry should never go away, because you're going to have to go through the process of probate. So let's talk a little bit about the decisions you need to make. That's your decision. You have to do it. You have to take care of your estate in any way you feel necessary. If you want your children to have it, you've got the beneficiaries that you've been trying to, build something for them, then you obviously want them to have as much as possible. You want them to get everything you can possibly give them. And there's only really one way we can do that. And that is something that I do a lot of. And most attorneys, or at least many attorneys, will do the same thing. It's not a difficult process. It's somewhat expensive in some states. Basically, I started doing trusts, which we're going to talk about now, in California. And 30 years ago, we were charging $2,500 for that trust. Now, Utah is not, or was not, that expensive. Today, it does run up around $2,500 for a simple trust. And you can certainly get it done for less. A trust is an object or an entity that can hold property. And it's been around for hundreds and hundreds of years. There are basically two kinds of trusts. There's the revocable trust and an irrevocable trust. And what we want to talk about and focus on today is the revocable trust, even though there are a number of others that we can talk about. You've got your revocables, of course. That's what we call a living trust. You've got your testamentary trust, Totten trust, charitable trust, generation skipping trusts, pot trusts, any number of kinds of trusts. But the most commonly used, and the one that I think is basically something that everyone ought to think about, is the revocable simple living trust. And it's something that doesn't take a lot of time to prepare. And once it's done, you never have to worry about anything again unless you get more property. And you want to make sure that trust is funded, meaning that you get all your property in that trust, and as a legal entity, it can hold that property. Now, what about it? What does it do? That trust will take care of the entire family, obviously, from the day you put it together, those living, and those that you leave your property to. One thing about a will cannot really have any benefit or utilization until after you die. A living trust is exactly what it says it is. It lives with you. And as a living trust, it's something that you can change, modify. You can do anything you want with it as long as you're alive. And it avoids all of the hassle of courts. The courts never get involved in a trust unless someone contests that. And I can tell you from experience, I've never known a trust to be contested, but I'm sure it could happen. But a trust is something that belongs to you. It's very individual. something that I would not suggest you try to do yourself, even though I know you can go down to the bookstore or even online, and you can find forms that you can fill out your own trust. That I would highly discourage. Get someone who knows a little bit about it to do that trust. That way you can feel assured that it's done properly. And there are a number of things that are of some concern in that trust to make sure it's done. Plus the fact, as I suggested earlier, it needs to be funded. And any attorney you use, make sure he helps you do that. Otherwise, you've got a great piece of work and a lot of paperwork and worth nothing. And that trust is something that I recommend everybody and anybody who has a home, who has minor children, who have bank accounts, absolutely must have, because otherwise that will go through probate. And a trust can be expensive. You can, as I suggest, typically pay anywhere between maybe $1,000 and $3,000. There are attorneys who perhaps will do them less, and there are others who may suggest they can do them who are not attorneys, and I suggest you also avoid those. Attorneys who do estate planning know what they're doing and can help you, and that's what I suggest you look to when you want to put that trust together. I can suggest that there are ways to get it done a lot cheaper than $1,000 if you find someone, and I do that myself because I don't have the overhead that a lot of attorneys do. Basically, anyone who's watching this webinar and participating in the games, I'm offering an entire package of the trust work for $600. Trust should comprise about 11 to 12 documents. There's a lot involved in it, and it needs to be done right. So get some good legal advice when you do that. Now, how does it work? A living trust is an entity that as long as you've got one put together, you've got it funded, it will last as long as you live, and in fact can last beyond your life, depending on how you put it together. It will obviously go to the beneficiaries that you've chosen, and that can happen almost immediately after your demise. The trust basically utilizes the use of 3 different capacities, all of which will be you and your spouse or you individually. And let me suggest something else while we're on the topic. A lot of people who have lost a spouse and have determined to remarry think in terms of a prenuptial agreement. Now, my experience again, and I've done a lot of prenups, think in terms of an individual trust as opposed to a prenup. It's worked wonderfully well for me and for individuals who want to protect their property. Later on, after you're married, you want to share that with your spouse, that's fine, but just protect it at the outset. Once you put it in your individual trust, you don't have to worry about a prenup because that property will always belong to you until you decide to share it or dispose of it. So if you're thinking in terms of prenup, consider perhaps an individual trust, what we call a personal living trust. That gives you options that a prenup can't. In any event, the individuals involved and necessary for a trust are the trustor or grantor. And as a married couple, that is in all likelihood both of you. You're putting the trust together, it's your trust. It requires trustees. And the trustees, again, as long as you're living, are you. That means you take care of your own trust, both husband and wife. Upon the demise of one, then the sole surviving spouse becomes the sole trustee. And we can get into a lot of specifics, but I'm going to try to keep it as simple as possible because most of my trusts that I do are what we call AB trusts. It's a marital trust and a passover or pass-through trust. And AB trusts give you the greatest advantage in terms of tax savings, federal estate taxes, and that's something trusts will do. Right now, your savings in a federal estate claim is somewhere around $11 million per person, just a little bit over. Our new president is suggesting that maybe it should go down to about 3 million. But for most people, that isn't that much of a concern. I certainly wouldn't worry about that in my estate. But in any way, the successors as a trustee, once both spouses are dead, then you've already named your successor, which could be a child, it could be a friend, it could be a member of the family, anyone that you want to manage the estate upon the demise of both parties. And that individual has a responsibility to simply disperse of the trust, get it out to the various beneficiaries, and pay whatever bills are necessary. And it's done, again, without court supervision, without attorneys, and very simply done. And the last party involved would be the beneficiary. And as long as you're living, you too are the beneficiary. So you're the grantor or trustor, trustee, and beneficiary as long as you're alive. That trust is yours. You can do with it as you wish. Trusts do not require, a living trust do not require a separate tax number. It can be your own tax number. You file your taxes just as you've always done. You don't have to change your checks or bank accounts at all. You simply put it in the trust as exactly as it is. It's a very simple process. Let's just quickly show a comparison between a trust and a will, if you can read this. Just go over that with you. As a will, it's a public record. It incurs fees, attorney's fees, appraisers, accountants, administrative fees. It's time consuming. We talked about that. Controlled by the court. And limited property encourages contention, which happens a lot. And it complicates lives. Your children or whoever is trying to put that will to its finish, they're going to spend time in court. They're going to waste a lot of time that shouldn't be wasted. On the other hand, the living trust, there's no probate. It's private. It saves money, minimizes taxes. It's immediate. It's flexible. Handles all property. Avoids lawyers and courts. Manages assets. Distribution is determined by you and provides for the family. As important as anything else, it can take care of the children and make sure that we don't have any problem with the courts in terms of where those children are going to go. They don't become wards of the court. You can determine who the children, minor children, are going to go to in that trust. And it's overall just a very simple, very wise thing to do. In my experience, I find a lot of people who just haven't thought about it. And when they hear the word trust, they're thinking in terms of big, big bucks. That's something that only rich people do, and it could be nothing further from the truth. It's a very simple and immediate and relatively inexpensive process if you get it done right. So finally, let's talk about how the trust is set up. And that's something that is literally simple. Once you get the attorney to work for you, he'll take the information that you need to have in that trust. He'll apply it, make sure that it's all done properly. He will hopefully help you fund that trust. And I've run into a lot of wonderful, well-written trusts that were not funded, which means that they're basically useless. So you want to make sure you get those items, your estate, into the trust. And it's a fairly simple thing. Let's just spend a second on that. If you have a home, you just redo the deed. Have the attorney prepare another deed, and then record it. The deed will name the trust as the owner of the home. But in all essence, you as the trustor, trustee, beneficiary still own it. It doesn't go anywhere, but it's protected. So once you get your property in there, all bank accounts, anything that's registered or recorded like a bank account has to definitely go into the trust. Because otherwise it will have to go through a probate process. Now, if you have property in another state, consider the fact that you not only will have probate in the state you live in, but you'll have probate in the state where you have that additional real estate. And something you want to avoid is obviously multiple probates. In a trust, you can put all that property, regardless of the state, in the trust. And essentially, 49 of the states have basically the same trust format, a few minor changes. The only state that I have not been able to do a trust in is Louisiana. They have a little different kind of law there. But an attorney basically located anywhere can do a trust regardless of where you live in the continental United States or Hawaii or Alaska for that matter. So it's something that you don't have to worry about, making sure you get someone who lives in a particular area or does work on a particular state. That trust is just one item that you need in that package. You'll also need a couple of powers of attorney, which is something that every trust package should have, a power of attorney for each of you and your spouse. You also need living wills. You want to avoid being hooked up to a machine mechanism and your entire estate being drained through that plug in a hospital. You need something also very important in a trust package is what we call a pour-over will. A pour-over will is actually an estate product, but what it does is it acts as a sort of a safety net in the event that you do not put property in your trust, so that you've got that particular pour-over will, which does exactly as it suggests. It pours it over into the trust. So if a court gets something that's not in the trust, you've got a pour-over will. They'll see what it is. It's a very simple process, and the courts will allow the trust to distribute the property. You also need a Schedule A. There is property that you don't necessarily have to title. Weapons, jewelry, artwork. If you want someone to, particularly a child or someone else to acquire that or have that upon your demise, you want that Schedule A to be filled out. It's an ongoing process. It's something that you don't have to finish right away, but as you acquire things or decide you want someone to have that, then you need to put that on the Schedule A. Another story quickly, my spouse, 4 sisters, when they wanted something, essentially they had a number of paintings in their home, very valuable paintings. So each sister would very conveniently put their name on the back of that painting so that it would be theirs upon the demise of the parents. By the time we got through doing the disposition of the property, there was a whole list of names, and all the sisters were on there 2 or 3 times, and then they thought that whoever were there last, they got that property. We were able to work that out. So that doesn't work. Fill that Schedule A out so you don't have any problems with the children. The last thing you want is problems with the family. Once you've got a trust and you've disposed of your property by suggesting who's going to get it, my suggestion is you don't share that with family. You keep it privately. And also, folks, take your money and spend it. Enjoy it. Travel. Do what you want. Your life isn't necessary to prepare for your children. I don't know whether you had that preparation from your parents, but the children will manage fine. They don't need you to live their lives for them. So enjoy your funds. Enjoy your estate. But if you do have something that you know is going to be left over, get it done properly. And I'm seriously about thinking of, in terms of a living trust. That is the way to go. And if you have any questions, I'd like to hear them. But otherwise, thank you very much for being here today. It's been a joy speaking with you. And I hope your life is one of great joy. Thank you.
Paul, thank you so much for that information. Wow, a lot of details there. We actually do have a couple of questions that have come through that I'd like to ask you. You alluded to a couple of them, so maybe just a little more clarification. But one of our attendees asks, should all property, including cars, jewelry, etc., be included in the trust, or just the big items like your homes, your businesses, those big items? What do you think about that?
Well, the Schedule A is for that purpose, Kyle. All your jewelry, that's the kind of thing you do not want the kids arguing over. And again, very quickly, maybe a little story. My grandfather, who died young, had a collection of weapons, and he had something called a 30-40 Craig, which was a rifle, lever action rifle that he let me use all the time. And that was to be mine. He told my dad, that belongs to Paul. Upon his death, and it was totally unexpected, My uncle got down in his basement, took all the weapons and sold them. That created conflict between my father and his brother that never ended. And that's the kind of thing you want to avoid. So with that Schedule A, you list those items, and hopefully you have someone that you want them to go to. So yes, everything goes into that trust in one way or another. And as far as vehicles are concerned, just one note, you certainly can put it in a trust. If you do that, make sure that when you transfer the title, it's done when you pay your taxes. Otherwise, you're going to be taxed again. So I only recommend people who with automobiles who have great value, cars that they've kept forever, cars that you just can't go down and buy. Put those in the trust for sure. But just your ordinary vehicle you're going to be driving around. In all likelihood, you're going to be changing that vehicle 2 or 3 times, before the day comes. So I wouldn't worry too much about that. But
Yeah,
that also includes boats, trailers, anything that's licensed.
yeah, that makes a lot of sense. One other question. You had mentioned earlier that your trust does need to be funded. The question is, what does funded mean? Can you elaborate a little bit more on what that legal term means?
Yeah, funding is an absolute, and that simply means getting your property into the trust, transferring titles of homes, your bank accounts, everything. Make sure you go down to the bank, get those accounts into the trust. Very simple process. They expect it all the time. Um, we didn't finish up in terms of all the documents involved. I won't spend time on that right now, but a lot of it requires a notary public, and you can do that at the bank when you go down to have your trust signed. And a couple of them require witnesses. That banks generally can do that as well. Sometimes the banks, when you go down to transfer your property or your bank accounts into the trust, they require a copy of it. Typically, what I will do is give people a certificate of trust, which is basically the same thing. It's just as a shorter document. And one of the documents that I like to have people have so they don't have to carry that trust around. And by the way, when you do have a trust, make sure it's put away. Make sure you know where it is. And again,
Right.
I wouldn't suggest you share it with the kids. You're going to be gone when they start dealing with it, so you don't have to worry about any embarrassment or any problems. So keep it to yourself.
Great advice. A comment here that I think is worth mentioning. We have a user, an attendee, excuse me, that said, my parents had a living trust. I was the executor. And when they both passed away, it made disbursement so easy for me. I'm so grateful that they thought to do this. So it sounds like people have taken advantage of it to their benefit. We do have another question here, and this was one that I had. You kind of alluded to it, but again, clarification. The question is, I live in DC. Can you prepare a trust for me per the offered package? Is that something, do you have to be in the state where this person resides, or can you prepare trusts outside of the area?
Now, basically, the trusts are pretty much the same in every state. Again, there are some modifications that need to be made, but I've prepared trusts in at least 20, maybe 30 states. So no, you don't have to go to that state or have an attorney in that state prepare it.
Okay. And then how do people get a hold of you? Do you have a phone number that people call?
I'll be happy to give my number to you. That number is 435-229-3133. Or you can get me online at Barrister, Barrister 60 at Hotmail, or barristerpjr@gmail. Love to hear from you. And if I can answer any questions, happy to do it. My clock doesn't start running when the phone rings.
Wonderful. And then one more last question. I'm sorry, two questions. These are great questions that have come in, and we want to cover them. How old should someone be to have a trust? What's your recommendation there?
If you have a child, if you have a home, you need a trust, whether you're 16 or 60. There's no age determination. If you have an estate of any kind with registered or recorded assets, then you need a trust.
And then you had mentioned, and I think this is good advice, rightfully so, that you want to keep that trust private to some degree. But this is kind of a logistical question. If you don't share the trust with anyone, how will anyone know it exists and know how to use it? So how do you recommend that during the transition or the transfer?
Well, that's a good point and a question that needs to be answered. you need to have your successor trustee, which is perhaps your oldest child or the child or a member of the family or someone who's going to actually distribute that. And by the way, you can have more than one. In fact, I recommend you have at least two, and they can work jointly or they can work separately. But you need to inform them that you do have a trust and where to find it and have it available to them when they need it. Otherwise, keep it locked up.
Wonderful. Once again, Paul, thank you so much for joining us. A lot of details. I think if anything for me personally, you shared a couple of things that will stick with me. One is the importance of a trust. I did not know a lot about that. In my mind, I think that's what you see in the movies. That's what you assume. That's what you're supposed to do. So the importance of a trust. And then also the how it can be just a little bit complicated, and you probably need to utilize some professional advice. So wonderful, wonderful information. Thank you so much, Paul, for joining us. You just have a wonderful afternoon and the very best to you.
Thank you for having me, Kyle. It's good to be here.
Thanks so much once again. And thank you for joining us today. If you enjoyed today's webinar, then be sure to let your friends know about the Living Your Best Life webinar series. And this presentation will be available to rewatch at seniorgames.net. We'll also include access to the documents that Paul shared today, as well as his phone number and email address. So if you're interested in following up with him, then you'll be able to do that. Also, be sure to join us next month on Thursday, March 25th, 2021, where we'll meet with Ronnie Daniel, and we're going to learn all that we need to know about Alzheimer's disease. We hope that you'll take just a moment to participate in our 2-question survey, which will pop up on your screen once we log off. And until we meet again, get out there and live your best life. Thanks, everyone.